What is a workers' compensation deposition? What is going to happen? Hello everyone, I'm attorney Nathan Howser, and in this video I'm going to provide some general guidelines and things to expect during your workers' compensation deposition. Now, first and foremost, I want you to know that a workers' compensation deposition is not, in California, is not something that's rare. It happens in almost every workers' compensation case. So there's no specific reason why you're here as opposed to somebody else. The deposition is a question and answer session between the attorney for the employer and between you. It's not an interrogation. Nobody's going to be pounding their hands on the table and screaming at you. It is simply a question and answer session between the employer's attorney, or the insurance attorney. Now, at your deposition, the attorney is going to be asking you questions about a lot of things, about your injuries, about past injuries, medical treatment, past medical treatment, and those are normal. They're questions that they need to know in order to have an evaluation of your case. The most important rule for the deposition is an obvious one. It's be honest. For every question that is asked, be honest. It is very difficult for your own attorneys to help you if you're not being honest. So just know you have to answer every question truthfully. Now, the attorney who's taking your deposition has 3 reasons to be doing so. The first reason is to determine your credibility. If that attorney thinks that you are not credible, you're lying, you're inconsistent, or a bad witness, then they will more likely want to fight your case and take your case in front of a judge because they probably think that the judge will not take your side. However, if you're a good witness, it's less likely that the attorney will want to fight your case because they'll probably think that a judge will find in your favor. So there's a better chance of reaching a settlement or a good settlement. Now, the second reason they're taking your deposition is to learn the facts of your case. Sometimes the attorney for the insurance and the employer do not communicate very well. So often they have very little information about what the case is about. So they're going to ask you questions about your injuries and everything that happened. Now, the third reason that they want to take your deposition is because they want you to commit to a story. So if you change your story at a later date, they would try to use that change against you to try to attack your credibility. Deposition is a proceeding that has the same force and effect as if you were in court testifying in front of a judge. There's going to be a court reporter present taking down all the questions and all the answers during the deposition. The court reporter will have you swear to tell the truth. After the deposition, about 30-45 days after, you will receive a booklet containing all the questions and all the answers, and you'll have an opportunity to make any changes that you think are necessary. However, any significant changes to your testimony will be used against you. So we want you to have your best testimony during the deposition. You need to take your time when you're answering the questions. Take a few seconds, sit back, and think about the answer before you provide it. Speak slowly and make sure that you wait for the attorney to finish asking the question before you respond. Now, I have 3 reasons for this. The first is you need to hear the whole question to understand what is being asked. If you interrupt in the middle of the question, even if you anticipate what the question is going to be, you may be providing an answer to something question that's completely different. So let the attorney completely ask the question before you respond. The second reason why you need to take your time is the court reporter can only take down one person speaking at a time. If you're answering questions before they're completely asked, then the transcript of the deposition is going to be very unclear. A doctor or a judge may be reading this deposition at a later time, so we want this to be as clear as possible. The third reason why you need to wait for the question to be completely asked is if I don't like the question for some reason, and that happens very often, I may want to make an objection to the question. You'll probably see my hand start coming out right before I'm about to make an objection. If you answer the question before it's completely asked, I don't have time to get my objection in. So I need you to wait. There's no hurry. There's no rush. Take your time. Allow me to make my objections. I want you to remember that the attorney who's taking your deposition is absolutely not your friend. that person's job is to attack your case or make it less valuable. Sometimes an attorney will be very friendly, even making jokes. They want you to be very comfortable. Don't get comfortable. I want you to remember that person's job is to attack your case. And I want you to respond only to the question that is being asked. Do not volunteer additional information. I want you to ask, or I want you to answer only the question that's asked and nothing further. There are very specific questions that are going to be asked, so you should be providing very specific answers to those questions. The best answers during the deposition are those that are short and simple. Yes, no, I don't know, I don't remember. Those are completely perfect answers if they are the truth. So for example, if the attorney were to ask you, do you know what city you live in? Most people's inclinations would be to say the city, but your answer should be yes if you know the city that you live in. Your response should not be Los Angeles, Huntington Beach, or wherever it is that you live. If you know what city you live in, then your response should be yes. If the attorney wants to ask you additional information, they need to do so. You're not there to just have a forum just to have an open conversation and speak. If you can answer a question with a yes or no, I want you to do so. If you don't know the answer to a question, or you don't understand the question, then I want you to ask for clarification or say, I don't know. If you don't remember the answer to a question, then you should say, I don't remember. Those are perfectly fine answers to say, I don't know and I don't remember if those are the truth. For example, if you are asked, have you ever had an injury to your back? If you don't know for sure, but you think it's possible that you had an injury to your back, then the better answer would be not that I recall, rather than no. And the reason is it's much less damaging to your case if later on the reality is that you did in fact have an injury to your low back. I want you to assume that the defense attorney that is asking you these questions already knows the answers to the questions that are being asked. It is very common that an attorney will be asking questions just to see if you are going to give the answer that they already know. I'll give you an example. I had a client who, during the deposition, was asked, what did you do yesterday? He responded, I sold some things at my house. The attorney asked, well, what did you sell? And he said, I sold a motorcycle. And he asked, did you help the person who bought that motorcycle load it into the truck or into his truck? And he said no. What happened was, the day before the deposition, the insurance company sent an investigator to sit outside of his house and film what he was doing. And he did, in fact, help the person who sold that motorcycle load it into his car or into his truck. He was providing the answer to the question that he thought was best for his case, rather than just providing the truth, which ended up making it much more damaging. So you always need to answer truthfully with all questions. Most questions can be answered in a few words. If you are talking for more than 7 seconds, there's probably a problem. Now, there are some exceptions to this rule, and we'll cover those, but short answers should be short and simple. You're going to be asked to provide estimates with regard to dates, times, weights, heights. If you can provide an estimate as a response to a question, please do so, but make it clear that you are providing an estimate or an approximation. For example, approximately 10 pounds. I don't want you to guess for any questions during the deposition. The attorney will explain to you that there's a difference between a guess and an estimate, and I'll do so now. You can probably estimate or approximate the amount of money that you have in your wallet, and that's because you have some personal knowledge about it. You probably looked at it this morning. However, if I were to ask you how much money is in my wallet, you would have to completely guess because you haven't seen my wallet. At least I hope so. So if you can provide an estimate to an answer, please do so, but I don't want you to guess for any reasons. You may hear me object to questions during the deposition. If I object to a question, I want you to answer it still unless I specifically tell you not to answer the question. If I instruct you not to answer the question and the attorney asks you, are you going to follow your attorney's advice and not answer that question? I want you to say, yes, do not answer the question. You cannot get in trouble for not answering a question if I instructed you not to do so. If there's an issue with that, a judge will have to take that up with me. So you allow me to make my objection, and then you can answer the question. A typical question I'll instruct you not to answer is questions about conversations that you have had with me or my office. Those are privileged communications, and you cannot be forced to provide the answers to those questions. Like, what did your attorney tell you about something? That's a question that I would instruct you not to answer. Answer all questions verbally. No uh-huhs or uh-uhs or shaking or nodding your head. The court reporter can only take down verbal responses. So if you are pointing to an area of your body where you're having pain, I don't want you to say it's hurting here. You would be saying it hurts on my neck. It hurts on my right hand. Say with words what it is that you are pointing to. It's fine to point, just make sure that you also say with words where you're pointing to. A neutral doctor or a judge may be reading this at a later time, and if the record is not clear that you are pointing to a certain body part, it may be confusing. So we want everything to be as clear as possible. A very important rule is if you don't understand a question, say you don't understand or ask for clarification. You absolutely should not answer a question if you don't know what is being asked. I have very many times had to clear this up in trials because my client was answering a question that he or she didn't understand. So make sure you understand the question before you answer it. You are going to be asked to provide an explanation of the body parts that you are having pain with. When you do that, I want you to take your time. It's very important that you take your time. During a deposition, it's something that most people haven't been in, so they're nervous. They try to move quickly. Take your time when you're asked where you're having complaints or where you have injuries. Do it like a list. Start at the top of your head and go down and cover every body part that you're having complaints with. After you do that, if there are additional complaints that aren't necessarily pains, for example, high blood pressure or complications with diabetes, then you would explain those after. So cover all of the physical complaints first, and then explain any other complaints that you may have. If you feel pressured and while you're explaining the different parts of the body that you are having complaints with, if you feel like you've forgotten something, you can say, that's all that I remember right now. And I would prefer that you do. If you think that you've forgotten a complaint, but in the pressure of the deposition, you can't remember, then say that's all I can remember right now. And when you remember, if it's during the deposition, you can bring that up. You're also going to be asked to provide an explanation of your job duties. I understand that this is not going to be a short and simple answer. It's very important that the reader of the deposition, whether it's a judge or a doctor, understands what it is that you did at your job. So provide a detailed explanation about what you did, but try to keep it as brief as possible. You're also going to be asked to explain what you do on a daily basis. This question is being asked because the attorney wants to know how your injuries have affected your activities of daily living. These are important questions because when a doctor considers your permanent disability, they will often take into account how your injuries have affected your activities of daily living. If the activities of daily living have changed from before the injury to after the injury, then I want you to explain those. The attorney is going to ask, are there things that you cannot do now that you were able to do before the injury? This is a very important question. Be honest and don't exaggerate. My general rule is you should never say, I never do something, unless you absolutely know it's true. And the reason is this. If you were to say that I never carry bags when I leave the grocery store, since my injury, I don't do it at all. The insurance company can very easily send somebody to videotape you doing whatever it is that you said you couldn't do, and that would affect your credibility. So if you're asked the question, are there any things that you never do that you did before the injury, I want you to think twice before you provide your response. If there's things that you do with difficulty or that cause pain, I want you to explain those. So when you're asked these questions, take your time and think about it. If you have difficulty putting your socks on, putting your shirt on in the morning, those are things that are important and that the attorney is basically asking you to provide him information about. We can take a break at any time. You are in control of the deposition. If you want to speak with me or stand up during the deposition, just let us know. I've actually had a client who was in so much pain during the deposition that he wanted to lay on the ground. So the deposition was taken with him laying on the ground. Whatever it is that you need, just let me know and we will do our best to accommodate. I want you to know something. My number one interest is to protect your rights. I absolutely will not let somebody try to harass you or intimidate you during the deposition. If there's any inappropriate behavior on the part of the attorney taking the deposition, we will adjourn the deposition. Now, there's some questions that can be asked that are uncomfortable. The attorney can be annoying, but I absolutely will not tolerate somebody harassing or trying to intimidate you. If I have filed your case, it's because I believe in the merits of your case. So I'm not going to let somebody try to make you feel like you shouldn't be pursuing your rights as an injured worker. So let's review the rules and guidelines for the deposition. This is a question and answer session. It is not an interrogation. The answers that you give should be short and simple and only provide as much information as the question asks. Always tell the truth and assume that the attorney already knows the answers to the questions that he's asking you. If you have any questions about your case, the specifics of your case, or would like a free evaluation, please call the number on the screen or text the number on the screen, and we'll be happy to coordinate an evaluation of your case with you. Thanks so much. Take care.